Good evening and welcome back to SF Live. I'm your host, Myrna Lim. Tonight we have a very special guest. We have Jeff Wu, an attorney, who is a special counsel for the law offices of Sedgwick. He specializes in real estate, in property law, among other things. And welcome, Jeff.
Thank you very much.
Great. So tell us, we have the rent control ordinance in the city and county of San Francisco. There is a continuing debate. The rent control ordinance seems to be a work in progress. Now, right now, before the Board of Supervisors, are three major changes to the rent ordinance. So could you outline all three and then we'll go back to each one of them?
Sure. Supervisor Daley has presented about 3 weeks ago a set of three changes to the rent ordinance, and they're broadly all packaged as a tenants relief package. And the goal of these changes is to provide tenants some purported relief from the rent that they pay. The first ordinance change proposal, that one seeks to limit the amount of annual rent increase and banked rent increase that a landlord can take to 8%. The second proposal would limit any rent increase that a landlord sought to take so that the total rent could be no more than a third of a tenant's gross income. And then the last proposal that Supervisor Daley has presented is a proposal in which tenants would be allowed to sublet their unit to bring in as many roommates as they want, so long as the total number of roommates did not exceed what was allowable under the housing code. And so those are the things that are being presented to the public as a stimulus package, so to speak, for tenants.
Okay, let's start with the first one. How does that impact existing tenants and or new tenants?
Well, so at first blush, all of these provisions seem like, a very positive thing for tenants, and naturally you would imagine that landlords would probably not want them. Most stimulus packages that we hear about in today's media have to do with the government providing some form of relief. These provisions are provisions which are going to go on the backs of landlords. And so naturally tenants are going to be interested in having them. It benefits them purportedly. But I think if you look deeper into these provisions, there is a lot of unintended consequences to tenants that they may not like. So for instance, the first provision, limiting the amount of banked rent increase and annual increase to 8%.
Right.
That sounds great.
Right.
What is a banked rent increase? A banked rent increase allows a landlord to go back and take rent increases that he may not have taken over several years for a variety of reasons. It could be that he had a great relationship with his tenant and thought the tenant was a great person and didn't want them to move. Could be the economy did not justify rent increases. Could be a friendship. But the reason why landlords have been willing not to take rent increases is because they knew they had the right later on to go back and get them when they didn't take them. So while this new provision would, in a sense, benefit tenants by limiting it to 8% in any 1 year, what the unintended consequence is that is not being discussed is the fact that if this provision were to pass, landlords would be essentially forced to raise rent every single year, no matter what, whether they love their tenant or not, whether there was no economic reason to raise rent. Landlords would be forced, and that's an unintended consequence that nobody's talking about. The second provision sounds also very attractive. It says that if you raise my rent, landlord, then I can file a petition with the rent board claiming a hardship, and if the rent board determines that the rent with the increase is more than 1/3 of the tenant's gross income, then the rent increase is not allowed. Well, of course, very attractive. But again, there are unintended consequences that I think tenants are not aware of and is not being talked about.
Okay, let's clarify right now the allowable rental increase per year.
The board publishes a number. So I believe this year it's something like 2% or 2.1%. It's not a very large percent.
Right. Okay, now let's go to the second proposal, and that is that the rent may not exceed 33%
33%
of a person's gross income.
That's right.
Okay, could you tell us about what this means?
Well, again, another proposal that looks very attractive on its surface, but the unintended consequences, there are several that maybe tenants are not going to like. The first one that comes to mind is that in order for a tenant to prevail on this kind of petition, he or she has to set forth what his or her income is. Now, there isn't any detail about how this is going to work, but as we can all imagine, if a tenant were to file this kind of petition, there would be a great dispute over what their income was.
Exactly.
It will come not only from what their paycheck says, there's going to be discussions of income that's not on payroll, maybe income that's not reported, things of that nature. So that's something that is going to create a lot of conflict.
Exactly. So let's clarify something. This provision applies to existing and new tenants, correct?
Correct. Well, and you bring up the point about new tenants. The other unintended consequence of this is that what is going to happen with landlords if this passes is that they're only going to want to rent to the most well-heeled, well-off, financially solvent potential tenants. If they're looking at a number of applications, maybe they want to rent to a young college student who maybe just graduated. Maybe his parents are even willing to guarantee the rent. But that landlord is probably going to be very resistant to doing that now, because he would be worried that if that tenant's income does not allow for the rent increase, then he's going to be barred from making future rent increases.
Right.
So for that reason, I think that tenants should understand that the long-term consequence of this is that it's going to make finding housing much, much more difficult.
Right.
There's a third unintended consequence that tenants should be aware of. In this city, there's been a discussion about means testing for the rent ordinance. Some people ask, why should tenants who earn $250,000 a year, for instance, be able to take advantage of the benefits of rent control? That's not what it was designed for.
Exactly.
Well, this ordinance is really going to bring to the fore, again, this discussion. And it's very clear that tenant advocates are not interested in ever seeing means testing happening, yet this ordinance puts it right back in front of us again.
Right. So, in other words, for instance, if you have a tenant who, as you say, is making $250,000.
Right.
And when this passes, and let's say they own another property in another location.
Sure.
How does this impact, and they have a rent control unit.
Right.
How does this proposal impact them and the landlord?
Well, it could affect in two ways. One is that if the tenant actually lives in the unit and makes $250,000, but maybe has other property, that happens, then what will happen is that this ordinance probably will not affect landlords at all, because the tenant makes so much money that that they'll never hit the 33% level. But if it's a situation where a tenant is using the San Francisco apartment that they've had for many years as a pied-à-terre, as a sort of a second home, maybe they have another home in Mill Valley and they stay here a couple nights a week. Well, it's unclear, but it's very likely that this ordinance probably wouldn't prevent a landlord from filing what's called a 121 petition, which says to the rent board, this tenant's this is not his principal place of residence, and therefore I should be entitled to a one-time increase to market rent. And I don't believe that this provision limiting to 33% of income would bar that from happening, though we don't know the final version of the law, and certainly it'll probably be litigated, and who knows what the answer may eventually be.
Well, what if you have a situation where a person decides, look, I just want to take a part-time job. You know, they had a full-time job, and they go, well, I just want to work part-time and, you know, learn how to sew or, you know, do some sailing and, you know, and so forth. How does that impact the landlord? And then would this apply to them?
It would. The way the proposed ordinance is written, there is really a very strict and black and white test. The rent board is asked to look at their gross income, not the potential for income, only what they actually make, and then it says that they must determine that there's a hardship and reduce the rent, you know, down to the 33% level if they find that. You know, and you bring up a good point, because if you look at other areas of law, for instance, divorce law. I mean, if a husband and wife get divorced and there's child support, if a father loses his job, well, then rent, you know, then the support might be lowered. But if a father decides that he just doesn't want to work anymore, a court can look at the circumstances of that and say, that's not very equitable, and that's not living up to the bargain that, you know, their obligations that they have. Yet this ordinance really doesn't address any of that, and it's just a black and white test.
So in other words, this partially could make people be, you know, irresponsible, really. If a person does not have to work full time, and suddenly, you know, they think that the law allows them to just earn a part-time income and not have to worry about paying a full rent, well, why should they work full time, right?
Yeah, I think it's a natural that if a person's tendency is to game the system, and you create laws that really enable that, then they will naturally take advantage. I mean, I have to say, I don't imagine that most tenants would want to do that. I don't see this law, this proposal, as a nefarious way for tenants to get something that they don't deserve. I think that the idea behind it, in terms of trying to find some way to help, you know, citizens of the city, you know, with the fact that we have a very difficult economy, well, I frankly think it's laudable. But I think that as a public policy, we have to look at the fairness of who is taking the burden of this benefit, and then we also have to look at these unintended consequences. And in the long run, I think what tenants and their advocates should look at is, will this serve them not only in the short term? You might get a rent reduction, or you might avoid a rent increase, but in the long term, is this really good for them? If tenants are going to have to be, you know, upper middle class or above to qualify to get an apartment, because landlords are scared that that undereducated or less educated or people with or lower paying jobs are worried that he or she will never be able to raise their rent because of this rule. The natural tendency of human behavior is to say, I'm not going to rent to them. It will have nothing to do with you know, it won't be personal. It'll just be financial, and I think in the long term people will regret it.
Well, how does this affect, say, landlords who are having a hard time? I mean, right now a lot of property owners are getting foreclosed on. Most of the time they find that their mortgage payment and the loan they have on their existing loan they have on the property is way more than the value of the property. How does that impact them under this scenario?
Well, it's a great point, and especially in this time, we are seeing a lot of landlords who are having trouble making their payments. The ordinance actually provides that once a tenant files the petition, and it's determined that the rent with the increase would exceed a third of their income, that the landlord can put up evidence that they are in a hardship.
Oh, I see.
And that if the rent board determines that the hardship to the landlord is greater than the hardship to the tenant, then the rent board is purportedly required to allow the increase. But unlike the way we examine whether a hardship exists for a tenant, we just look at whether it's more or less than 33% of their income. There are no standards for looking at what it is for a hardship to a landlord. So we don't know how hard it's going to be to put up a case that a landlord is suffering a hardship. There are no standards.
Exactly. Well, right now, from what I understand, there's over 10,000 units that are vacant because a lot of property owners have decided that it's just not worth their while to be renting out a lot of these units. Would this make that situation worse, do you think?
Well, yes. Anecdotally, it's said that there are 10,000 units or more vacant. We call these vacant by choice.
Right.
And no doubt that if these ordinances were passed, it will only cause those who are inclined to keep their units vacant by choice. It'll just give them more reason to want to keep their existing vacant units vacant and perhaps keep more units vacant as they become freed up.
Now let's talk about the third item in this proposed amendment to the rent control ordinance. The proposal to allow tenant to bring in roommates and so forth. Could you elaborate what this means?
Sure. In most written leases, there's a provision in the ordinance that says that if you want to bring in a roommate, you have to seek the consent of your landlord. San Francisco currently has two provisions in the rent ordinance that say that if you want to replace an existing roommate, then you can do that once a year, even if your lease says you can't. Okay?
Oh, I see.
And then there's another provision that says that if you want to bring in a relative to live with you,
right,
and by doing so, really you're increasing the number of people that living in the unit,
right,
well, then you can do that too. What this proposal would do would be to completely open the floodgates and simply say that no matter what the lease says, that a tenant can sublet and bring in as many roommates as he or she wants,
interesting,
so long as the number does not exceed what the housing code of San Francisco allows. And the housing code of San Francisco is quite generous, frankly.
Right.
What it provides is that if a sleeping room must have at least 70 square feet for two people to sleep in it. So 70 square feet is a room that's 7 by 10 feet.
Right.
It's like two closets, very small.
Right.
For every additional person that would be sleeping in that room, you only need an additional 50 square feet. Okay, so quite a small space again.
Right.
So, for instance, in an average studio apartment in San Francisco, 450 square feet, not particularly big, average size.
Right.
Legally, you could fit 9 people or more into that unit. Now, you or I may not want to live in a studio apartment with 8 other people, but the thing that is not being talked about here, the unintended consequences to tenants that is not being discussed, is that if I as a tenant have a neighbor, another tenant, who decides that they want to move 9 people into their studio, is that something I'm going to like? Well, probably not. I mean,
exactly.
And I'm going to...
Well, how about the parking situation?
Well, how about the parking? How about the water?
Right.
How about the, just the use of services?
Right.
And the thing is about it is that not only if I was a tenant that I can't do anything about that,
right,
my landlord can't do anything about it. And and because my landlord can't do anything about it, my landlord would have no control over who moved in, those 9 people. We don't know who their identity is.
That's interesting, though, that this amendment would preclude landlords from enforcing binding, quote, contracts or agreements they sign. How is that possible?
Well, that's sort of a shorthand. The way it works is this.
Right.
What it says is that it doesn't say that the contract is unenforceable. What it says is that you cannot evict a tenant if they move people in and it's less than the number that's allowed under the housing code. So the practical effect of it is that you can't enforce that provision in the contract.
Wow.
If I can't evict a tenant for having 9 people in a 450 square foot studio,
Right.
well then there's nothing I can do. I'm just stuck with them, and so are all the other tenants in the
Right.
building. And I don't think that that's what people want. I think, that there is an idea that, for instance, a 3-bedroom apartment,
Right.
the average size in San Francisco, we calculate that you could have 25 people
Right.
living in that unit. And, we're trying, as a city, maybe we like a little density, but
Right.
that's getting well beyond the realm of reasonableness.
Wow, well, we're running out of time. See how time goes so fast when we're talking about items like this, proposals like this. Anyway, thank you for coming, and I believe this recommendation, this proposal has been heard before the full board and has been assigned to a committee.
It's been assigned to a committee. It's actually under the 30-day rule.
Okay.
So nothing actually has been
right.
talked about yet. So we're waiting.
Well, so anyway, you could call Chris Daly and other members of the Board of Supervisors to weigh in on this very, very important proposed change to the rent control ordinance. Ladies and gentlemen, thank you so much for joining us tonight, and we'll see you again next time. And again, this is Myrna Lim with Jeff Wu. Thank you, Jeff, and we'll have to invite you again to explore more of these issues as it moves forward. Thank you so much, and good night. Joining us tonight.